Hi, this video is about a change in the landlord-tenant statute, more specifically a change in the security deposit statute that happened in 2023, technically with the name of Senate Bill 23-184. This is the statute that says security deposits cannot exceed 2 times the monthly rent for a property. And we're specifically talking about this in the context of how it relates to post-closing occupancy agreements. That is the situation where a seller is selling a property to the buyer, but part of the deal is the seller gets to rent back the property post-closing. And the reason this is relevant is a common arrangement is an arrangement in which there is no rent for the seller getting to lease back the property. But nevertheless, the buyer, who is becoming the landlord, wants the seller to put up a security deposit. Well, if the statute applies to post-closing occupancy agreements and there is no rent, 0 times 2 is still 0, and there can be no security deposit. So, first question is does the statute apply to post-closing occupancy agreements? After all, they're called post-closing occupancy agreements. Maybe they're not leases that are covered by the statute. No, that argument does not work. I'm not going to go into the legal analysis. That argument does not work. The statute is broad enough to cover all rental agreements, and this would certainly, a post-closing occupancy agreement would certainly be subject to the limitations of the statutes. Well, another thing we hear is, well, the buyer and seller agree to this, what could go wrong? Well, it's easy to see what would go wrong. The seller stays in possession of the property. A month later, 45 days later, 60 days after closing, turns over possession of the property to the buyer. The buyer goes into the property, is disappointed with the condition of the property, does not want to release the security deposit, and the seller, as the tenant, has a lot of leverage to jack the buyer around as the landlord, and the buyer may be very, very disappointed about how weak their position is getting any of that money. Okay, well, people say, oh, you're just a lawyer and you think of the worst case scenarios. There's got to be some workaround around this. Okay, so I am recording this video in May of 2024, and I have seen workarounds that have been proposed for this, language workarounds. They might work, they might not work. But if they don't work, do you want to be the source? Do you, as a non-lawyer, as a real estate broker, want to be the source of a cute arrangement that did not work? Do you want to be accused of the unauthorized practice of law? Well, I'll let that be up to you, but I wish I could hand you my card. I am discouraging my clients from being the source of the workaround, other than the following, which is, so if the seller doesn't want to pay rent, increase the price enough to induce the seller to pay rent. So, for example, if the buyer was buying the property for $500,000 and the seller wants a post-closing rent back, and the buyer wants rent of $1,000 a month, make the price $502,000 to induce the seller to pay that 2 months of rent, which, by the way, could be collected from the seller at closing. not changing the buyer's net cash at all, not selling the seller's, changing the net to the seller at all. I acknowledge it would require the property to appraise for 502, not merely 500. But that's the best solution that I have to offer you. Think about it. In the meantime, thanks for listening this long. Be careful out there. We live in a complicated world.